So are you normally with Miss Apple or Mr. Gaddy?
Mr. Gaddy.
Okay, now I get it. Okay. It's not Miss Apple's fault. Okay. All right, you're requesting an adjournment?
Yes, we are.
All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Virgil Stafford.
Just another position.
There he is.
This is public defender in Apple, appearing on behalf of Mr. Stafford, who's from now. Mr. Stafford, will you state your name for the record?
Virgil Stafford.
In your honor, we have reached a resolution.
Yes, I do see. He's going to plead guilty to.
An attempt, count two, an attempt resisting obstructing.
Yeah, the problem is, I'll fix it, but it just states next to the primary charge. The PAC code is for the attempt, but got it. Okay.
Thank you.
He's going to be pleading guilty to the charge of attempted resisting and obstructing an officer, the 1-year offense. Upon a successful plea to that charge, that count two, count one would be dismissed. There is an agreement by the defendant that he will comply with all court orders for mental health treatment, comply with all medication plans. Defendant has a probate case, I'll just leave it there, that was transferred to Genesee County in June of this year. That's the court's full understanding.
Yes, Your Honor. That's correct, Judge. Thank you.
All right. May I have him sworn?
Solemnly swear or affirm the testimony about truth, whole truth, and nothing but truth, so.
Virgil Virgil Stafford, Stafford.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bravo in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Okay. Were you on probation at the time of this offense?
Yes.
All right. You understand that your entry of a plea in this case could be considered a violation of that probation.
Yes.
You understand that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge.
Yes.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense, sir?
Yes.
On the date of January 16, 2025, at the location of 300 Briarwood Circle, City of Ann Arbor, Washtenaw County, State of Michigan, did you come into contact with officers of the Ann Arbor Police Department?
Yes.
What happened?
Sorry.
Go ahead. You may volunteer.
Thank you, Judge. On that date and time, you came into officers that were with the Ann Arbor Police Department, correct?
Yes.
And you knew that they were officers with AAPD?
Yes.
Okay, and they ultimately asked you to step out of your vehicle, correct?
Yes.
Okay, and you complied with that, but then they informed you that they were going to detain you, correct?
Yes.
And to place your hands behind your back?
Yes.
Okay, and you did not comply with that order,
No.
correct?
Yes.
Great.
All right.
Defense is satisfied.
Okay. Very good. Sir, if I accept your plea, I do have to advise you that if between today's date and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you first of all would not be entitled to withdraw your plea. And secondly, any sentence agreement or evaluation, the court would know. Counsel, are you aware of any other plea promises, threats, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
July 29th at 9 a.m. with Judge Bell.
July 29, 2025. What time, I'm sorry?
9 a.m.
9 a.m. with Judge Valwell. And will continue. Thank you,
Thank you, Judge.
Court does call the case of the people versus Darnell Taylor.
Alexander, we have a people, Your Honor, but she is in the hallway charging his tether.
Doing what?
Charging his tether.
On our bill? Go ahead. I'm talking about, that's why our DT bill's so high. People come here to charge it.
Thank you for my appearance on maybe. On behalf of Mr. Taylor, will you state your name for the record?
Darnell Taylor.
Thank you. Your Honor, we are
How
asking,
long was he charging for?
oh, maybe 15, 20 minutes?
35 minutes.
35, just kidding, on my time.
35? Figure out the DT rates. Give me a number, we'll make it pay. All right, go ahead.
Your Honor, Mr. Taylor is asking that this matter be set for a preliminary exam.
It has not been sent over to defense counsel, nor has the 911 call. The media notice was made, I believe, 2 days ago, and the 911 call still has not come in yet, so they do not have media discovery nor 911 call.
And Your Honor, that is correct. I informed Mr. Taylor of that. I informed him that the court would be asking if discovery was complete. We do not have the video. Mr. Taylor is still insisting and requesting that the court proceed with the preliminary exam. I fully advised him of the risks of that, considering one of the allegations is from the back of the patrol vehicle. We do not have video of that, but he is asking that the matter be set for an exam.
Sir, you understand that could be a problem for you? Because if the discovery comes in and people have it, your counsel hasn't had a chance to look at it, you're not going to get an adjournment of these proceedings.
Yeah, I understand.
You understand that?
Yes, Sean.
Do you think it might be better that your attorney would be able to look at what it is, particularly since some of it was involved in what I understand the back of a police vehicle, prior to making or being able to fully advise you as to how to proceed?
Yeah, Sean, I understand. I mean, at the end of the day, I honestly don't think it's going to make a difference.
So you got your law degree where?
I don't.
Yeah. And I think she said it, so it's not really impinging on your privilege. She's advised you that you probably should wait till they can fully assess it.
Did I advise you of that?
Yeah, she did.
Okay.
Don't you think it might be advisable for you to follow your lawyer's advice?
I do, Your Honor. But at the end of the day, I mean, I know what I did.
Well, no, whoa. I don't want you.
Okay. Well, I didn't do.
I do know. Hold on. Here's what we're going to do. Over your objection, I'm going to adjourn it. I'm going to make sure that it's fair to you and that you have what you need to make a proper call rather than rushing into it. Okay.
I understand. Yeah. My main thing was I'm on this tether and
I know, but you don't want a circumstance where, and I'm not saying that it will, things can get much worse for you. Let your attorneys do the job for you. Okay.
all right.
You got good attorneys around you. Let them do their job. Okay.
All right, Your Honor.
All right. So we think we'll have that by when?
Probably sometime next week, Your Honor.
Okay. So if you get it now, instead of going to the 7th, I'll go to July 31st.
Thank you.
Okay. 2025, 9 a.m. And then at that point, after you've seen everything that's there and your attorney, most importantly, has seen it, then you can make your decision.
Thank you, Judge.
Fair enough?
Yes, sir.
All right. And just because you actually listen to me, I'm not going to make you pay for the use of electricity.
I appreciate
All right. Take care.
Thank you.
Court calls case people versus Vershawn Vincent.
That's the line for the people.
Sorry. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vinson. Your Honor, I don't believe with Mr. Vincent. I will take the blame for this one. Mr. Vincent typically appears on Zoom. That was my apologies in missing the deadline. I submitted it late. I've had communications with Mr. Vincent up and through today and just a few minutes ago. He lives in Detroit. He does not have transportation. But he was not able to make it here today. He tried everything he could over the last 24 hours to get a ride. But unfortunately he could not appear in person. We do have a misdemeanor resolution on this case. We just need Mr. Vincent to get here.
Gosh, she's so nice and eloquent. I hate being nice. People have any objection if I adjourn this out, given those circumstances? Who is it, Londi?
Yeah.
Oh, boy. This could get bad.
The only problem is Mr. Vincent has a very significant history of failing to appear.
He does, but I think since that,
Since he's been coming on Zoom, it's been better,
yes, exactly. And
but it's still not great.
If I could let the court know,
wow.
just one additional thing. Mr. Vincent, we had a lengthy conversation yesterday. He's prepared to accept the offer. I informed him that we'd be asking for one more adjournment. And then my request is that he appear in person in 2 weeks at the adjourned date so that he can sign the waivers. We can make sure to have that conversation so that everything is signed and done. He informs me that he'd be able to get a ride, that's enough notice, and he would be here. So if the court is gracious enough not to issue the warrant, I will ensure that everything that I can do, that he is here in person and he has enough time.
Noting the people's reluctance to agree, and I understand, and looking at the file that he's had some issues, I'm going to grant the request. I'm going to adjourn it out to July 31st, 2025, 9 a.m.
Thank you.
Continue. Thank you.
Thank you, Judge.
Then what?
And we got
I get a break? All right, court stands in recess.
all right.
Good job, baby. I like names there.
You may be seated. Okay, this court is back in session. The honorable case subject to presiding.
You may be seated. Court does call the case People versus Cheryl Andrasick.
McManus, P41543, on behalf of Cheryl Anderson. State your name for the record.
My name is Cheryl May Anderson.
Anderson. Okay, sorry for mispronouncing your name. I have before me a plea form that indicates that the defendant will be pleading no contest. Do I have a report?
Ally's on behalf of people, Your Honor, I believe we submitted the report on
Is this the one?
May, but it was separate from the. I do have a copy here.
It wasn't even, was it one of the ones? Okay.
Yes, it was.
I didn't have a plea form with it though, right? Okay, that's why I probably don't recognize it. All right. It should be pleading no contest to counts 3 and 4. Counts 1 and 2 would be dismissed. And there is sentencing under, well, it says 4A, but presumably that's 769 4A. That's the court's full understanding of the agreement. Is that correct?
It is correct, Your Honor.
All right, very good. May I have her swear?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So
Go ahead and lower your hand, say it, and then spell your name.
my name is Cheryl. Cheryl, Cheryl, M as in 9th of May, Andrysek, Andrysek.
All right. Ma'am, it is this court's understanding that you're going to plead to 2 misdemeanor charges of domestic violence. Is that your understanding?
Yes,
All right.
sir.
Those are misdemeanors.
For my actions.
That may be the ultimate, but do you understand what it means?
That I did something wrong. And I'm pleading guilty to it.
You're not pleading guilty. They're allowing the judge to make a determination of guilt based on the police report.
Okay, yes.
Okay, so one thing, there are two things really I need really for you to understand about a no contest plea. The first thing is that it means that you're not further desirous or wanting to contest these two charges. You understand that?
Yes, sir.
You understand that also I will be, as I think counsel was indicating, I would and have reviewed the report in this case and would use that as a factual basis to determine whether or not a crime has occurred. Do you understand that?
Yes, sir.
All right. The other thing you need to understand is that for purposes of sentencing, the court will treat you the same.
Yes, sir.
All right. You have any other questions about a no contest plea?
No, sir.
All right. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced before Judge Perry in the 15th District Court. You understand that, Dan?
Yes. Yes, sir.
All right. Any other questions regarding a no contest plea? Or anything so far?
No, sir.
All right. Basis for the no contest plea, counsel.
Basis, Your Honor, civil liability.
All right. So, ma'am, to the charge of domestic violence as contained in count 3, how do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
So you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
All right. Do you have any questions regarding any of the right 5? And underneath counsel, there's one. Yeah. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights that are on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
All right. Are you on probation or parole?
Yes, sir.
He is on probation in Savannah, Ohio, Your Honor. She
All right.
understands the ramifications of this plea.
All right. And were you on probation at the time of this offense?
Yes, sir.
Okay. I do have to advise you that if you were on probation and this were considered, and your pleas in this case, if they are considered a violation of that probation, that the other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead no contest?
Yes, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record, get you to plead no contest?
No,
And you or coerced you in it?
no, sir.
You're doing this voluntarily
Yes, sir.
of your own free will?
Yes, sir.
All right. I need a copy of the report. Thank you, sir. The court has been provided and has previously reviewed Ann Arbor Police Department report for their case number 25-14640. Any objection to the court having reviewed that report?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of these offenses. Ma'am?
Yes.
I do have to advise you that if I accept your plea, from the time of your plea to the date of your sentencing, if there is misconduct committed by you as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court also would not be bound by any sentence agreement or recommendation. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 22nd at 10:30 with Judge Perry.
August 22nd, 2025, 10:30 before Judge Perry. Bond in this case will continue.
Thank you very much.
Thank you.
Thank you.
Court does call the case People versus Zachary Brown.
Douglas for the people?
Afternoon, Your Honor. Dan Garrett on behalf of Zach Brown. He's stepping forward.
Good evening, Your Honor. I'm Zach Brown.
All right.
Not quite evening yet, is it?
No,
No.
that's okay.
We're getting close.
He's young, so it might be.
There should be a green sheet in your honor's file. We're asking for an adjournment to consider an offer that was made today.
All right. 31st or 7th, sir?
You have a preference?
7.
7th, please, your honor.
7th. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, your honor.
Thank you, Your Honor.
I'm sorry. Court does call the case of the people versus Virgil Dunlap.
Good afternoon, Your Honor. Victoria Burke here, Assistant Prosecutor here on behalf of the people.
Good afternoon, Your Honor. Edward Drukas on behalf of Virgil Dunlap.
All right.
And Your Honor, can you state your name? State your name.
All right.
Your Honor, today's the time and date set for our PCC. I did fill out a green form. I'm asking for a adjournment to further negotiate. I'm also in possession of a bond violation report.
Yes. What does your client have to say about that?
Regarding that, when it was received, we have been looking for inpatient programs. He is here with his nephew today. There are 2 programs where he's on a waiting list, the Home and New Vision in Oakdale. He is a bed away. That's the direction that we're going.
What?
That's the direction that we're going, is getting into some assistance for substance use, as noted in the report. He has also been taking care of some other ailments. He was at Trinity Health this morning. He's got some referrals. He's had a bunch of different things that he has medical wise that he needs to take care of.
But he tests positive for fentanyl, heroin, opiates, and amphetamines.
Okay.
And cocaine. Well, sir, yes, I do see it on the new one.
I don't have the report from yesterday.
What?
I don't have the report from yesterday, but I do know that there's been 3 tests that have been received.
Right.
And also get 5 over 10.
Does he admit to these violations, Lee?
He would admit to them today.
I'll accept that admission. I mean, and his next test is pending that he took on the 16th. I don't have any hope that it's going to show up any better. Grant your adjournment of the probable cause conference. I'll set that for my earliest next date, really effectively is July 31st, 2025 at 9 a.m. At this point, given the violation testing, and it doesn't appear to be getting any better. In fact, he's just adding drugs to his system. At this point, the court's going to revoke the defendant's bond. Defendant's going to be remanded to the Washington County Jail pending further hearings. Because I will sign an order if it exists that may allow him to be released or at least screened for inpatient treatment.
Okay.
All right.
Thank you, Your Honor.
Need to go with my. Court calls case People versus Benjamin Hoffman.
Alexander, on behalf of the people, Your Honor.
Hold on 1 second, guys. I don't know who's back there. I'll scare them, get them up here. They should know, but. Okay. Did they go back to the hall maybe?
Alfred Brand on behalf of the defendant, Your Honor.
All right. I have a plea form in front of me that indicates that the defendant would be pleading. Well, hold on. All right. It actually goes up here on the form, but that's okay. He's actually pleading no contest to count 3, the domestic violence.
Correct.
Correct, Your Honor.
And also an added count for attempted interfering with an electronic communication device.
That is correct, Your Honor.
All right, that latter one being a 1-year offense, the other being a 93-day offense. stated count 3 on his successful no contest pleas to those charges doesn't, okay. Counts 1 and 2 would be dismissed. Okay. All right. There is also an agreement, a sentence agreement of sentencing under 4A or no objection for the domestic sentencing under prosecutors deferred on count 4.
Correct, Your Honor.
That is correct, Your Honor.
All right. That's the court's full understanding. All right.
Correct. And we did not check off the sentencing judge waiver. I believe he'll be sentenced before your.
It's my case.
Correct.
All right. All right. Very good. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. State your name for the record, please.
Your Honor, my name is Benjamin Hoffman.
All right. Sir, it is this court's understanding that you are going to be pleading guilt or pleading no contest to 2 charges. Is that your understanding?
Yes, sir.
First being that the charge stated count 3 of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that? Also, that you'll be pleading no contest to the charge of attempted interference with an electronic communication device. That being a misdemeanor punishable by up to 1 year incarceration, a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
I do.
All right. 2 things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. This plea counsel.
Civil liability, Your Honor.
All right. Sir, to the charge of domestic violence, how do you plead?
Contest.
To the charge of attempted interference with an electronic communication device, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. There's a copy on the podium underneath the paperwork there. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-11370. Any objection to the court having reviewed that report?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to these offenses. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules from this date to the date of your sentencing, that to be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
And the court would not be bound by any sentence agreement and or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 4th at 1 p.m. with you.
being me. August 4th, 2025, 9 a.m. Or is that 1 p.m.?
1 p.m.
1 p.m.
And Your Honor,
That's before me. Yes.
people could respond.
Uh-oh. Yes.
Your Honor, it's my understanding that Ms. Hoffman, the victim in this case, is here today to request contact if the court would like to hear from her.
I'll always hear from her, but go ahead. All right. Yeah. You'll have to step over that way.
Find a spot, Your Honor. Have Mr. Simon.
Yeah, make him move. Hello.
Hello, I'm Anna Hoffman, and I'm the victim in this case. Your Honor, I am here today to request that you lift the no contact order with the defendant. The main reason being that we have 3 children, and it's been very difficult to parent without communication with the defendant. There's also numerous household issues and maintenance problems that have come up that I need to be able to communicate with the defendant in order to resolve. And I need to be able to contact and have communication with him about our best course of action as a family going forward. Whether that be through reconciliation or separation, which I intend to continue for this time, we need to be able to have those conversations, especially for the sake of our children. So I'm asking, Your Honor, that you please lift the no contact order. I have no reason to believe that I am under any sort of risk of this happening again due to his conditions that I've learned since the incident. So I feel completely safe and comfortable with this option, and I'm asking you please to lift the no contact order.
Right.
Okay.
Thank you.
Thank you.
Did the people have any position?
Your Honor, we'll leave it in the discretion.
Anything you want to say regarding the request to lift it up?
Just a couple things, Your Honor. So in talking to my client, he's not intending to move back to the house. However, he does need to have contact with his wife because they have 3 minor children. The AC unit went out the other day. My client's an engineer. Him being able to get over to the house and help is helpful. So we'd ask for the no contact to be lifted, but his intention, so we're very clear, is not to move back in at this point. Separate and
All right.
separate and
But just so that I'm clear, he would intend to go to that location, but he's not intending to move back in and reside there.
correct. That is correct.
Okay.
Your Honor, we have one other matter separate and distinct from that. My client oversees 200 engineers. He is required occasionally
Oh, really?
to leave the.
Engineers?
Yeah, that just.
You know how lawyers feel about engineers? And there's like 200 of them, like a whole herd. Go ahead.
I thought it was a gaggle, but
Yeah, you know, it might be the proper term.
So he has to leave the state of Michigan occasionally and the United States, but at least for this point, we're asking for him to, if he needs to leave the state for employment purposes, job purposes, he'll be afforded that opportunity. If in fact he has to leave the United States, we would file a petition with the court, put the court on notice, give the court written documentation for that. We don't have that today because we're not anticipating it within the next couple of weeks, but he may have to.
I have a position on that.
Your Honor, as long as documentation for when he's traveling is provided, we would be willing to do a stipend order for that travel when it comes up.
For the overseas travel, because I was going to allow him to travel in the United States for work.
We can do that, Your Honor.
Okay.
Thank you very much.
So if you prepare an order to that effect, that's fine. What I will do regarding the contact is I will delete.
Kept breaking up in there. I had to come in here.
Really? Yep. Yeah. All right. I will delete the no contact and the no go to. I will add to the bond conditions no non-consensual contact with Anna Hoffman. You understand, sir, what that means?
Yes, sir.
All right. So if for whatever reason she does not want you in her presence or around her, then it is your obligation to leave. You understand that?
Yes, sir.
All right. Okay. So that we're clear, I've taken the prohibition against going to the address, the prohibited address, off completely, have not replaced it with anything. I replaced the contact provision or the no contact provision with a no non-consensual contact. All right.
Thank you very
And
much.
I am permitting him to travel in the United States for his employment purposes.
Thank you, Your Honor.
All right. Bond will continue otherwise. All right.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Ahmed Al-Jabori.
That is the people.
Counsel, you're muted.
Good afternoon, Your Honor, to you and your staff. Brian Berry appearing on behalf of Ahmed Al-Jabori.
Sir, can you please state your name?
Ahmed Mohammed Al-Jabori, Your Honor.
Thank you. All right, what are we doing on this?
Judge respectfully ask for an adjournment, waive his right to have a preliminary examination within 21 days, just so that I can seek additional discovery and also have an opportunity to speak to the prosecutor in this case.
All right. That objection, I will adjourn this matter to August 7th, 2025. I set it at 9 a.m., but likely your case will be called in the afternoon block.
Judge, one more request, if I may. Thank you, Judge. Client, before the charges were brought in this case, the client and his family had booked travel to the state of Florida, to Orlando. Wife, the husband, and 2 kids. I've received verification of the same, and respectfully ask the court if he can travel between those dates and if we can maybe
What were the dates?
August the 2nd through the 15th.
Oh, that's miserable down there. He really does want to go? No, I'm kidding. Do the people have a position on that?
Your Honor, I believe that if there's documentation provided showing that he does have return tickets for the 15th, I'm not object to a family vacation.
All right. So I will permit travel. Why don't you contact the prosecutor, submit to the court a stipulated order regarding that, and I will sign that.
Thank you, Your Honor.
All right.
So the August 7th date, can we have a different date, Judge?
Pardon?
The August 7th would fall within that travel time.
And now this is 2.
I
Okay,
thought
never
that-
mind. I can, so basically the first half of August, he's traveling for our purposes. I don't have the I have what, the 19th is mine,
August 14th.
but he's gone to the 15th.
Oh, sorry. August 19th.
No, it's okay, pay attention.
No.
So what's my next date?
August 19th.
Thank you, that's what I said. Jeez. Thank you, Hannah. August 19th.
Thank you, Your Honor.
All right, thank you. Anything else, counsel?
No more one more things.
All right. Thank you. Have a great day.
You as well.
Thank you, Your Honor.
You're welcome. Court does call the case. People versus Demetrius Caldwell.
Actually, good people.
And good afternoon, Your Honor. I know you were just waiting for me to get off Judge Slay's Zoom. Perfect timing. Sydney Rushing appearing on behalf of Mr. Caldwell. Mr. Caldwell, can you unmute your mic, start your camera, and state your name for the record?
Demetrius Caldwell.
Thank you.
Rushing, do you really think you're that important?
Your Honor, I definitely
No,
do.
never mind. Never mind. Don't want an answer. Go.
Judge, I definitely do not. I just know that you are great at calling cases on the perfect time. That's all I was saying. Your Honor.
I appreciate that. Thank you.
Yes. So, Your Honor, we are here today for a PCC. Mr. Caldwell has not been able to have his interview as of yet. He was scheduled for an interview back on May 29th. And when I did send the documents, I tried to send the documents to his guardian who is on the Zoom with us today. The email, for whatever reason, did bounce back to me. I am asking Your Honor to refer him one more time for this interview to get completed. I don't think we should have another issue going forward.
And Your Honor, of course, we do want to get Mr. Caldwell evaluated so the case may continue. But based on the letter that, as I recall, from the Center for Forensic Psychiatry, I don't know if they're going to do it again without him being in custody at this point, because it's that I may be misremembering. So whatever we can do to accomplish that is fine.
What letter are you referring to that indicated that?
Your Honor, if I may.
Yes.
Part of that letter, so I have a few other cases in another county that also had this same issue. They've added a part in all of their letters. It is being sent to anybody who missed a hearing, basically saying that due to the voluminous amount of people who have missed hearings before, they are not they are not rescheduling those unless they have a re-referral from the court, is essentially what that came down to. But it wasn't just they didn't put that in there specifically just to Mr. Caldwell. It's something that they're putting into every paper or every letter that a person has missed that hearing.
Right, I get that part.
Oh, I misunderstood it, Your Honor. I thought it said something different than it did. It's my mistake.
Yeah, I don't think it was requiring me, it just needs a new referral. They're not gonna hold on to the other referral. So what I will do is, we'll just start this over. I will then, you'll submit an order to the court for forensic evaluation. I'll sign off on that order. I'll set a competency hearing in this matter for October 16th, 2025, 9 a.m.
Got it. I'll get that right over here. Thank you so much.
All right, bond will continue. Thank you. That's called the case People versus Adrienne German.
Maybe there were two people.
And good afternoon, Your Honor. Hassan Bezi on behalf of Mr. German, who is present. Mr. Can you unmute your phone and state your name, please?
Can you hear me now, Your Honor?
Yeah, state your name, please.
Yes, we can hear you. State your name.
Good afternoon. My name is Adrian German.
All right. All right, what are we doing on this case?
Judge, I had a chance to talk to Mr. McGirt yesterday, and we're asking for an adjournment in this case, and we also filed a motion this morning. I sent it to your clerk with regards to permission to travel.
Have you reviewed that, Ms. McDonough?
I have, Your Honor. No objection.
All right. You have an order in here, and I will sign off on the order permitting travel.
Thank you, Your Honor. And with regards to discovery, I did also submit it. I'm sorry, I forgot to submit it to the email address for discovery, but I did have a chance to go over with Ms. McGuffey yesterday. We need some time anyways, because there's a strong possibility of a resolution in this case.
August 7th, 2025, 9 a.m.
Would that be enough time, Ms. McDuffie, to get some information?
I believe so. We should be good.
All right, bond will continue.
You said August 7th, Your Honor?
Yes, sir.
Thank you.
Thank you.
Have a good day, your staff. Thank you.
And can you have Ann prep that order for my signature? Court does call the case of the People versus Torrance Oaks.
Ready, Your Honor. Your Honor, Joe Simon, on behalf of Ms. Oaks. She's making her way forward.
Torrance Oaks.
Thank you. You're requesting an adjournment?
Yes, Your Honor. I reached out to Ms. Douglas. She's going to make some inquiries. I'm going to defer to her to how much time she thinks she needs.
Your Honor, a couple weeks.
All right, well, I'll go. I think I put the number of yours on the 7th, Mr. Chairman.
You're correct.
So I'll adjourn it out to August 7th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Yeah. Thank you.
And it's not like I'm keeping up with your schedule. I just have to.
You just have a great memory.
I have big red flags on my calendar when you're going to be here.
Is there going to be an interpreter there?
You know what? That kept me up all night. Court calls the case People versus Lawrence Peck.
Good afternoon, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And Your Honor, Joe Simon on behalf of Mr. Peck. Larry, state your name. Lawrence Peck.
All right. And you're again requesting an adjournment.
Yes, but this one, Your Honor, I spoke to Ms. Burton Harris. She'll confirm. There's another matter that is pending investigation that's reliant on a blood test being returned. So we're asking for a longer, before we talk about resolving all the matters, we're asking that the court give a longer period of time to adjourn this PCC.
All right.
Read your eyes and see that you're looking at me for confirmation. That is correct.
Because I don't believe him. Yeah.
That is correct. I can confirm, Your Honor, we had that discussion, and in order to wait for that blood to return, which it'll take a number of weeks, we agreed that we would ask you for a longer adjournment.
19th be enough time, or you need something at the beginning of September?
Probably the latter.
Probably early September, just to be safe.
What do you have?
September 18th.
18th? That's like way in September.
Would you like it earlier in September?
I'll just pick my own date. September 11th.
Fair enough.
Why is that so hard over there? You guys,
There's only two of us, Your Honor.
two of us, one date. We can't figure that out. All right. Okay, thank you. Bond will continue.
Thank you. We'll write you a confirm. Okay.
Court just call the case, People versus Deshaun Tompkins.
That's a lot of good people.
And Your Honor, Joe Simon on behalf of Mr. Tompkins. And Mr. Tompkins, state your name right here.
Deshaun Tompkins. Thank you.
Your Honor, asking the matter be set for a preliminary examination.
Discovery complete.
Yes.
People have their witnesses available the 29th.
Could we go one?
No.
Please?
That I'm
You
available.
can.
I'm available on the 29th or August 12th, either one of those. The one in between, I'm not.
I never pick my date.
I know, but you're trying to.
I'm trying to not pick a date.
Same as me, I guess. That would be true.
If we could, Your Honor, if you don't mind, I would just like.
The August 12th day?
Yes, please. Thank you, Your Honor.
That objection, preliminary examination in person, August 12th, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
You are good to go. One thing real quick. Thank you, Your Honor.
Bond will continue. Does call the case of the People versus Charles Boyce.
Christina Berturian for the people.
And good afternoon, Your Honor. Gregory Sheen on behalf of Mr. Boyce, who's present via Zoom and consents to being on the Zoom call today.
Sir, can you state your name?
Yes, Your Honor. My name is Charles Boyce.
And what are we doing?
Your Honor, at this current time, we're going to request an adjournment. Mr. Boyce has been offered a second OWI. He is going to take advantage of that. He has been assessed. He's just set up for a screening. If we can do that August 19th, that would be wonderful. I think everything will be completed by that date.
Did he pick a date? He did. People have any objection with the 19th?
No objection for the date. I just want to clarify for the record that the offer is it OWI second with treatment court?
That's correct. So
Okay.
I'm sorry.
And so the assessments you're looking at getting are for the purposes of getting into a treatment course.
Exactly. I apologize.
That's correct.
Okay. Probable cause conference will be adjourned August 19th, 2025, 9 a.m.
Thank you, Your Honor. Have a wonderful day.
All right, bond continued. Thank you. Court calls the case People versus Ronald Lucky.
My favorite to make nothing for the people.
Good afternoon, Your Honor. Robert Ellman, with and on behalf of Mr. Lucky. Your Honor, Mr. Lucky, you approach.
Long time no see.
It's good to see you.
Good seeing you. All right.
Mr. Lucky, can you please state your name for the record?
About James Lucky.
And Your Honor, just because it's been so long since I've seen you, may we approach briefly?
With McDuffie?
Of course.
And you? No.
Pretty please.
Come on.
Approach in chambers.
Oh, we could. Thank you for the bench conference, Your Honor.
All right. Guess there are two issues. I guess one is prohibited from going to the address that he has a no-go to, except with a civil standby.
Correct.
My understanding, he's been there a number of times, which can be problematic.
Always with the police.
Sir,
Hold on.
sir.
Sorry.
Let him talk first, okay?
But my understanding, and correct me if I'm wrong, Mr. Ullman, that you pointed out to the court is that each time that he went there, he contacted the police, effectively instituting the civil standby.
Correct, Your Honor.
And that the number of times isn't because he's trying to go there to do anything, to do anything bad. It's just that he's trying to get his property and they can't get into the unit.
That's correct, Your Honor.
Okay. Well, they won't let him.
The homeowner won't let him in.
Homeowner is saying no.
Correct.
Okay. So he's in regard to what the defendant is doing, who is the subject of the bond, he's doing exactly what we would request that people do. He's calling the police. He's doing the civil standby. It's not working out because of entry on premises.
Can I say something?
If you want to.
Justin does not own the property.
Okay. So
The owner of the
sir,
property.
Sir, I don't know that and I can't resolve that today. And I couldn't resolve it in any event.
The owner of the property's been there.
Can you just listen to what I'm saying without interrupting?
Yes, sir.
Because that usually turns out bad for people. What I'm trying to point out and what your attorney was stressing to me and wanted to make sure that the court understood is that you had done exactly what the court would request that you do, so that if there was any request that you were going there trying to do something bad, that in fact, so you should thank your attorney for that. Okay? And sometimes if you're ahead, it's just better to just not say anything. Next issue, Mr. Allen.
Well, and I guess, Your Honor, I apologize. Maybe I'm asking for clarity. Are there, and I don't know, presuming that we'll call him the tenant of the home for sake of argument, refuses to further let Mr. Lucky into the property to reclaim his belongings. I'm assuming there, just for clarity, there is no order the court at this point could put on the tenant to force him to allow Mr. Lucky to retrieve his belongings.
I really can't do that. It may be fortunate if it's a tenancy type of situation instead of an ownership. It may be best to contact the owner to have them meet you there and have the owner give, if that's indeed the circumstance, because I don't know, have the owner give permission to go in and then see what the police would say to that.
Oh, thank you, Your Honor. I appreciate the clarity.
All right.
He's been there 3 times with the police.
I understand.
All right.
Your Honor, in my second issue, Mr. Lucky and I have discussed this matter. Unfortunately, I do believe that we are at an impasse where there is a breakdown in the attorney relationship. Given our conversations and potential strategy plans, I'd be asking to withdraw at this point.
Mr. Lucky, what's your position on that?
I just asked him to let the courts know that the owner was there 3 or 4 times with the police giving consent.
You know what?
That's all I asked.
The problem is we're not there. If there's an accusation that you've been at this, you don't seem to quite get this. There's an accusation that you were at the premises a number of times, maybe without a civil standby. Your attorney came.
Don't cut the judge off.
Your attorney came prepared to tell the court that you had done exactly what you were supposed to do. And he did that. All right. I can't solve all the problems regarding the civil standby. The next question was asked. I, again, don't know if the owner's there. So that's all that I can say to that. All right. And Mr. Owen, you think that the relationship between you and the defendant have broken down to the extent that you can no longer effectively represent him?
Unfortunately, Your Honor, I do. And I apologize. I don't take this lightly.
And yes, I know that, sir. You don't do that. But what I will do, I won't grant your motion at this time. I think because you were appointed on the case, you're going to need to get to the MAC office for the preparation of at least some order. I will grant your request, but I need the order so that you can do that, so that this matter is not It hasn't been delayed all that much in any event, but
And I guess, Your Honor,
yes.
forgive me if I understand this process wrong. I'm just trying to think of expediency for Mr. Lucky's sake. I know he wishes this case to move forward as quickly as possible.
Which you've also expressed to the court, and I know that you're trying, Mr. Earl.
And so if I were to go to the MAC office and let them know, if they were to just send you an order for my withdrawal, would there be a need for
Well,
the file a
they'd
motion?
actually send, yes, they'd actually send the motion with the order with the new attorney.
And so you're indicating if we did it that way, there'd be no need for a motion hearing or?
There'd be no need for that.
Okay, thank you.
Okay. But then I'd have to make sure that the attorney would have time to catch up. So what I'll do, you do that. I'll adjourn the probable cause to my next practical availability, which will be the 31st of July. You'll have a new attorney. Hopefully they'll be ready to go or to do something, and we'll have had contact with you. And that gives enough time. So July 31st, 2025, 9 a.m. or as it indicates, I'm sorry. And bond will continue. So if you get that order, if I get that motion in order to me, I'll sign off. And then there'll be a new attorney on the 31st.
I'll stop in their office right now, Your Honor.
All right.
Thank you for your understanding. Good luck to you, Mr. Lucky.
Court calls the case, People versus Lauren Michaels.
Hey, Pierre Tamika, for the people.
I hate it, counsel, articulate enough to get the point across to me. Or I'm just dense and I can't understand.
Tried very hard there. I'm sorry.
It's okay. All right.
Mr. Elman said that I was nice to him. I just want to put that on the record.
That is correct, Your Honor.
All right. Sorry, Mr. Savage, if you could put your appearance
That's
on.
all right. I was going to ask Joe Simon to give me a hand with this case, but he left. I'm kidding. That being said, may it please the court, my name is Matt Savage and I represent Lauren Michaels. Judge, may I represent her this afternoon with her being in absentia? She is still in a residential facility for her mental health treatment. She's now back in a facility called Rose Hill.
Yeah, I will. I'm very well aware of the circumstances. Counsel has kept surprised, and so unless there's an objection from the people, we'll proceed with the defendant in absentia.
Objection.
All right. All right. So what do we want to do on this case?
Your Honor, Miss Michaels was doing well. She was in St. Joe's Hospital for a while being treated. Then she went to Rose Hill, and then there was a setback there. And she was placed in the facility called Samaritan Behavioral Center. And now she is back in Rose Hill as of yesterday. At least that's what I was informed from her guardian. I'm hoping sooner than later we'll be able to get her here and resolve this case. At this point, what I'd like to do, and Ms. McDuffie, correct me if I'm wrong, I believe I've provided an independent evaluation. That all being said, that's my hopes. It's been a long 3 months, unfortunately, with Ms. Michaels. Sometimes she's very lucid, and sometimes she's not. But the medication that she was on last she was doing well, and then I'm not sure what happened. I tried to get information earlier today about that, and I was unable to. That's my hope. So I'm asking the court for hopefully one last adjournment on this case. Maybe I won't give you a date. But maybe late August, early September of 2029.
That I could do.
Yeah.
Is it September 4th? September 4th.
Yes.
All right. Why don't I adjourn this out to September 4th, 2025 at 9.
That sounds good, Judge. Just one minor potential issue with that. I'm supposed to start a jury trial on the 3rd in Macomb County. I'm hoping that case doesn't go. But if it's gonna go, I'll anticipate that earlier that week, and I'll reach out to the staff and maybe we can move this court date.
Okay. And this case is plagued with certain difficulties.
Yes.
So I will if that becomes a problem, if the date becomes a problem, I don't see any harm if we're moving it a little bit further out. So if the parties could send in a stiff to adjourn if that becomes an issue, Mr. Savage.
Perfect. Thank you, Your Honor.
All right.
And Ms. McDuffie, I'll be in touch with you soon. Thank you.
Okay.
Thank you. Court does call the case of the people versus Michelle.
I'm coming, buddy.
Lovas.
I'm coming, buddy.
Is that a dog or a child?
Jacob Kennedy for the people, Your Honor. John Shea, Your Honor, with and on behalf of Ms. Lovas. Your Honor, we are still awaiting discovery in the form of supplemental medical records. And so we're requesting a 4-week adjournment to continue our search for those.
All right. Would the 19th work for you of August?
Yes.
That's a Tuesday.
I think it will.
All right.
So that's 5 weeks then, right?
Yes. Well,
I'm sorry, did you say?
I said August 19th.
My calendar isn't, I see that as a Tuesday.
It is.
Very good.
I'm kidding.
I was anticipating a Thursday.
Yes, and it's that week. I'm actually going to try to do a vacation, so it'll be a double up docket.
Wonderful.
So August 19th, and that's it. That's in the morning, so that's a 9 a.m. call, and bond will continue.
And Ms. Lovaz has appropriately corrected my misspelling of, or my mispronunciation of her name.
How is it pronounced, man?
Yeah. Are you? No, you can talk.
Go ahead.
Lovaz.
Lovas.
Thank you.
Okay. I will remember that for exactly the next hour. And I probably will mess it up next time I call it. I'm just going to let you know. Okay. Thank you, ma'am.
Thank you.
Wait. Court does call the case of the people versus Francis McMullen.
John Shea, Your Honor, with and on behalf of Ms. McMullen.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor here on behalf of the people.
Your Honor, may Ms. Burton Harris and I approach?
Oh, boy. Yes, you may.
Thank you.
This could be an issue.
Thank you, Your Honor, for,
right,
I understand you're passing this matter for the.
Yes, I'm passing.
Very good.
Yes. She took that. She took it. She took it. Oh. Court does call the case people versus Danielle Noonan.
Counselor Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. You're muted, Danielle. You have to unmute.
There.
Sorry about that, Danielle Noonan.
All right, there we go. Okay, what are we doing on this case?
Your Honor, Ms. Londi and I have been discussing the matter. We're asking an opportunity to have my client screened for the FTC. We think she would be a good candidate for that. So we're asking for an adjournment, maybe 2-3 weeks, 3 weeks.
All right, very good. I'll adjourn the probable cause conference to August 7th.
Your Honor, can we have the 14th? I'm not going to be here on the 7th.
August 14th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Both case people versus Alexander Sanchez Garcia.
Jacob Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present standing to my right. Mr. Sanchez Garcia, please state your full name for the record.
Alexander Sanchez Garcia.
Very good. You're requesting an adjournment?
I am, Your Honor.
I'll adjourn the matter to August 7th, 2025.
Your Honor, I know that you just picked a date, but prior to solidifying that date, would it be okay if Mr. Kennedy and I approach briefly? I know, I'm sorry.
I'll talk to you. It's Kennedy. Come on. Record to reflect, there's been a bench conference in this case. I will, instead of the 7th, I'll adjourn it out to the 19th of August.
Understood. Thank you, Your Honor.
All right, 9/8. Thank you.
Have a nice day.
Bond continues.
Thank you, Your Honor.
Court does call the case People versus Cyrus Abadi.
Jacob Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Uwe Daus. I'm with and on behalf of Mr. Abadi, Cyrus taking in for the court, please. Good afternoon, Your Honor. Cyrus Abadi here.
Thank you.
We're looking to set this for preliminary examination, please.
All right, all discovery is complete.
Yes, it is.
People have their witnesses available on the 29th.
You are, Mr. And we will as well.
Preliminary examination will be set for July 29th, 2025, 9 a.m. That is before Judge Barr.
Very good.
All right, thank you.
Thank you.
Good to,
Thank you, Your Honor.
thank you. Bond will continue. Okay. They're filling out a form. They're gonna do a police report. We don't have an answer yet. We're waiting on a return phone call. I'm gonna take a break, see if we can get it soon. If we can get it soon, then I'll take the play. All right?
Thank you, Your Honor. All right. All rise. Continue to come back in session. The Honorable Day Subject Simpson presiding.
You may be seated. Court does call the case of the People versus Francis McMullen.
Harris, Chief Assistant Prosecutor, and appearing on behalf of the people in this matter.
John Shea, Your Honor, appearing with and on behalf of Ms. McMullen.
Your name, ma'am?
Francis McMullen.
Thank you. And I have been handed a plea form that indicates that the defendant will be pleading no contest to the charge of public officer purchased goods for a private purpose, misdemeanor punishable by up to 90 days. Upon her successful no contest plea to that charge, counts 1 through 4 will be dismissed. I would also note on this, while the file is marked as a 14A2 file, and as a 14A judge, I could just keep it, but with respect to Judge Barr, counsel let me know that there might be an issue. For purposes of the record, my office did contact Judge Barr's chambers. Judge Barr indicated that had this case, or if this case came to him, he would have likely disqualified from hearing the sentencing, so it would have come back to me in any event. So with that, I will keep it for purposes of sentencing.
Thank you, Your Honor. And I anticipated Judge Barr probably would have said that.
Pardon?
We anticipated Judge Barr probably would have said that, but I appreciate the court streamlining it.
Yes, and just in review of the report, Judge Barr's official capacity with the city of Ipsy is prevalent. And
absolutely.
So I think it absolutely appropriate. All right. Having said all of that, may I have her sworn, please?
You raise your hand. You solemnly swear or affirm the testimony you're about to give the whole truth and nothing but the truth, so you got it.
I do.
Lower your hand and state and spell your name again.
Francis, Frances, McMullen, McMullan.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of public officer purchase of goods for private purposes. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. Do you understand that?
Yes.
Yes. Yes? All right. Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. It first of all means that you're not further desirous or wishing to contest this charge. You understand that?
Yes.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
Just please, Mr. Shea.
Potential for civil liability.
All right. And ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights that are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will?
yes,
And because you believe that you are, well, I won't ask that part because that's not part of it. The court has been provided and has reviewed Michigan Department of State Police report for their case 548-23. Any objection to the court having reviewed that report?
No, Judge.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of this plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, number one, you would not be permitted to withdraw your plea. And number two, any recommendation or evaluation regarding sentencing. You understand that?
yes,
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge, thank you.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Satisfied, Judge.
Yes, Judge.
All right. Court will accept the defendant's plea of no contest to count 5. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 13th at 9 a.m. with you.
all right. Will that work for you?
What day is that? My calendar just screwed up, Judge, if I could, just a second. August 13th, it works for me. It's a Wednesday.
Yes, it
Is that okay?
August 13th, 2025.
9 a.m.
I said it at 9 a.m., but you'll get an assigned time block, and that will be before me.
Oh, this is another one of those floating time dockets.
Yes.
That is, okay, gotcha. All right,
all of mine are.
Yeah, are they all really done?
Yeah.
Okay.
Yep.
All right, very good. We will await the final notice about a week before from Ms. Ann.
Yes. All right, and bond will continue.
Thank you very much.
Thank you.
thank you.
Thank you, Ms. Harris. Ms. Burton Harris.
Thank
Is Laura still here, John?
Laura's not here today.
Okay. Should we contact probation?
Is Elon's not here?
I just believe it is Brian.
Okay, we'll check.